Welcome. Hi, I'm Ida Reis, certified divorce lending professional. And this interview is part of a series, a divorce literacy series through the Divorce Lending Association. And it's a unique project that we're really excited about because we're bringing family law professionals and related professionals together to benefit families who are either in the midst of divorce, maybe thinking about it, or post-divorce, and some of the issues that come up for those families, to help them to make really good decisions for their families. And today I have with me Steve Berger. Welcome, Steve.
Hi, Ida.
And Steve, would you kindly provide us with a little bit of background on your practice and what you do? Thank you.
Okay. Our practice specializes in estates, trusts, probate, and trust administration. My background was I went to the Air Force Academy. I was a pilot, and then I went to the University of Maryland Law School and started in general type practice. And in 2012, I started my own firm, strictly limited to the estates and trusts area.
Perfect. So once in a while, you do run into clients that maybe were just recently divorced or come to you saying we're going to get divorced and we need to know what the estate issues will be?
Yeah, I run into both of those categories.
Okay, yeah. Perfect. So we want to get your expertise on these. So tell us about, what, particularly people that have children, and what are the issues in divorce as far as estate planning go? What things should they think about, and how, if they were sitting in your office, what would you tell them?
So the big thing is the guardians. So, if something happened to one of you, the other parent is going to be the guardian. So there's not much you can do about that. But if something happened to both of you, it would sure be nice if there was some kind of agreement that you've named the same people. If not, we have everybody just name whoever they want, and then it'll be up to the court to decide between the two choices. And if one person doesn't do anything, then the person that's decided, their naming guardians in the will should be honored by the court.
That's good. So if one person does nothing, then the other person's choice will take precedence, I guess, is what you're saying. Okay, and tell us about a situation which seems to be more common now, and that is remarriage and what we call the gray divorce. People, like, I guess, beyond, actually from 55 up. Can you tell us a little bit about what the issues are with that scenario?
Okay, so that's where we have, typically two people come together, they're both divorced, or one's divorced and one's widowed, and they have their own families, and they want to do their estate plan. They want to leave what they have to go to their children, but while they're together, they want to provide for each other. And the two things that we run into, first is that Maryland elective share now covers everything, and the surviving spouse is entitled to a third of your trust assets, assets passing via beneficiary designation, and assets passing under the will. But you can waive that with the premarital agreement, and that's what we usually recommend if that's your goal, to pass it on to your children and just provide for, assuming you each have enough to provide for each other, or leave some so the survivor has enough to live on. And the other thing to remember is if one person needs long-term care, you're both on the hook once you get married, and you're not going to get Medicaid, even if the one person maybe didn't bring much into the marriage and the other person had a bunch of assets. The person with all the assets is going to be paying for the spouse that goes into the nursing home.
That's interesting. Okay, so you're saying, did I hear you correctly, that when you have a couple, two people that want to be married, and they have children, they have heirs, and they want to separate the estates for their individual families, they should have an agreement before that precedes the will itself, like a prenuptial. Is that what you mean? I mean, did I understand that correctly?
Yeah, right. So you would
Yeah.
do a prenuptial agreement so that if when you add things up, you're saying, this is mine, this is hers, and maybe there's some that's joint, but we don't want everything to go to the survivor, and the first to pass, their children would end up with nothing.
So in that case, then the prenuptial would establish what would go to each family. And then when you come together for the will, that establishes, kind of makes reference back to that, and then establishes what would stay in their joint assets. Is that right?
Well, kind of, or
like
typically we would put, each person would create their own trust.
Okay.
And then maybe they would have some joint assets. And even if it was somewhat unfair, that prenuptial agreement would stand and said that that's fine because you agreed to before you got married.
Okay. That's great. That's great information. If you had to leave our audience with some advice, where you're sort of, if you were sitting with a family friend or something, or your family, and you want to say, hey, you really should be concerned about this. Is there something you want to say to the audience about that?
So the biggest thing that I see is, so technically, if you get divorced, even if you don't redo your will, the spouse is removed from their position. If they were the personal representative, or if they were receiving something under the will, they would lose that just by virtue of the divorce, but the rest of the will would still stand. However, if you have beneficiary designations, something that's passing like your 401k or your life insurance, and you don't change that, that's going to go to your former spouse. I've seen that many times, and it's really a hard situation especially when you have a second marriage afterwards, and the new surviving spouse finds out that, say it's the wife, that her husband has left things to her wife, that they've been divorced for 30 years and they never changed the life insurance policy.
Yeah, and it's still, okay, so change the beneficiaries. Yeah, that's great advice. Okay, do you have any final thoughts for our listeners, Steve, before we end?
Well, that's my big one, is to get your will redone and get your planning done. Make sure that you've got a little bit of money left when you come out of the divorce to get that done, because even if the law removes the spouse, it's not really what you had intended. Whatever you had, if you'd done a joint will, and typically you're giving everything to each other and then to the kids, but maybe your spouse was the guardian, and his sister is now the trustee for your children. That's probably not what you want. So, and that wouldn't revoke that part about his sister being the trustee. So yeah, you need to make some changes as soon as you can, depending on when the separation agreement is effective. And you need to talk to your family law lawyer and say, at what point can we redo that will?
Okay. So it's important to do it, I guess, maybe towards the end of the process, or certainly right after the process, to get the will changed. Yeah. Well, perfect. Steve, if our audience wants to get in touch with you when they want to speak with you, how would they access you? Can you give us your website with your contact information?
So it's bergerwills.com, and it's BERGER, then WILLS.com, and we have links to everything, and you can see all our videos and And we have forms and some information.
That's
Give
great.
us a call.
That's great. Thank you so much for giving us your valuable time today. We appreciate it, and I'm sure our audience is going to appreciate it as well. Thank you so much.
Okay, bye, Ida. Thank you for having us.